our criminal justice system is set up in a way where we don't tar and feather somebody based on the sins of the past. We do that in the public, right? But in a court of law, there are rules about what's coming in and what's not. Is it more probative than prejudicial is the basic test. And if the prejudicial effect is such that it outweighs any probative value. So something like that may have such low probative value, but the prejudicial impact, even if it's slightly higher, that's getting it out of there. It's not coming in. And so you really have to look at what's the connection to this particular crime, right? Mm-hmm. And how is it being brought in? How is it relevant to the analysis? In the rules of evidence, the prosecutor, we're very much limited on the types of evidence we can bring in. It has to be specific to this crime. If it relates to prior conduct, as it relates to prior intent, as it relates to all these other things, the way the case law is set up is it ensures that those things are very relevant and very probative and are closely connected to the crimes that are at issue. And unless it has that connection, a judge is not going to let it come in. And it also goes back to those foundational things of, how do I know that he's the one who said this? If this is a post, how do I know that that is his user identity and that somebody else didn't post it on his behalf, or somebody didn't create an account and post this? Because there's all these different ways of spoofing this stuff, right? Mm-hmm. And so it really is behooves me to get that. If I want to use it, I need to connect the dots. If I want to use it, I need to convince the judge why this is relevant to this particular case and how it still has bearing 10 years, 50 years, or 10 years, 5 years, 1 year in the past, like how that ties in. So, that's where some of that stuff that we can't really control comes in. Is it ultimately is also a judge's discretion as to whether or not something should come in. They're the gatekeepers of the evidence.
Yes, definitely. So there will definitely be a lot of evidentiary motions before any sort of trial. So,
but even as a prosecutor, I will tell you that you want to put your best foot forward. You don't want to be putting in evidence that is a stretch, is a reach, or is very, very weak. Because the last thing you want is the Court of Appeal saying, hey, yeah, Mr. Prosecutor, you got a conviction, but this piece of evidence should have never come in. I don't even know why you tried to get this in. This is really pushing the envelope. It's very prejudicial, and therefore you're going to have to redo this again. So now after a conviction, 3 years, 5 years later, boom, you're starting all over again. So, that's kind of the situation that you're looking at. Is you want to be careful with what you're actually choosing to introduce. I think in terms of what they've talked about and delineated in this affidavit, as I've kind of explained, these are all powerful pieces of evidence. It is circumstantial evidence, but circumstantial cases are based on taking one thing and another thing and putting it all together and making a puzzle out of it, because you don't have a situation where you have direct evidence. Because if we were always relying on direct evidence, that was the only thing, there would be tons of cases that would simply be not prosecuted because your eyewitnesses are dead or don't exist, right?
That's right. Okay. I don't think you said you knew much about the Dan Markel, the law professor murder case. Have you heard about this? It's in Florida. Has to do with...
No, I have not paid much attention to that.
Okay. Yeah, because a lot of the things you've touched on are issues that people have been talking about in regards to the Dan Markel law professor murder case in Tallahassee. So okay. Charlie Adelson is his former brother-in-law who's going to be on trial next spring for being part of the murder conspiracy. It stemmed from a bad divorce and child custody case between the law professor and his ex-wife. So I've been covering that a lot on my YouTube channel, but I know you're too busy to watch it all. But so a lot of the people out there watching right now are also big fans of the Dan Markel case, and we're all glued to all the details. But similarly, there are allegations out there that Charlie Adelson had sold steroids and marijuana, that he had, gone on sex tours to other countries and, done all sorts of shady things. But I don't think those things would be admissible in his murder trial.
Not unless it was relevant to establish motive. So, for example, if one of those businesses or things that they were doing was connected to the conspiracy, was a motivation behind the conspiracy to commit the murder, I think that might come in. But oftentimes when we're thinking about dirtying up somebody, right, when you're sitting there and you're saying this person's bad because they did X, Y, and Z, that stuff's not coming in a trial unless that person testifies. So if a defendant chooses to take the witness stand, then immediately their credibility is put into question. And that's true with any witness that takes the witness stand. And so you can cross-examine on the facts and circumstances on the case, but you can also, to the extent the court allows you, to attack their credibility in other ways. Well, you were convicted in the past of defrauding grandmothers. Is that correct? Right? You were convicted or charged with selling drugs. And what you're looking at are crimes of moral turpitude. You and I understand what that means as lawyers, because it prevents us from getting a bar card, right? And there's certain other professions where, crimes of moral turpitude are, count against you. But the whole point of it is, what is the nature of that other conduct that casts a light on somebody's credibility? And how do you prove that? If it's a conviction, a court's going to let you use that, assuming it's not decades in the past. But if it's some allegation that, let's say, the neighbor down the street says, well, I saw him steal this person's lawn chair, is the judge going to allow a separate small trial on whether or not this guy stole a lawn chair to affect his credibility during the course of a trial? That's what a judge is going to decide. I don't really want that. I don't want a side trial on it, so I'm not going to let you in. Ask, Mr. Prosecutor. You don't get to ask isn't it true that you stole the lawn chair? I mean, if he says yes, then there's no small trial. But if he says no, I now have to bring in the neighbor who's going to come in and say, well, I saw him steal this lawn chair. And then he's going to cross-examine and say, oh, yeah, well, the reason why you say that is because you and I have been fighting about our Christmas ornaments for 12 years. And now suddenly I'm like, I have no idea what's happening here. I've lost complete control over this, right? So you have to look at what it is that's being used to attack the credibility, and a judge is going to make that decision of, is this coming in or is it not? And like I said before, as a prosecutor, I need to figure out, do I want to use this or do I not? What's the most effective way of me challenging this person's credibility? But in a lot of homicide cases, quite frankly, the defendant's not taking the testify. Mm-hmm. It doesn't necessarily help them. And oftentimes their attorneys will tell them, don't do it. We don't want you to be up there getting attacked by the prosecutor. In some instances, you have to, because you're putting on a self-defense. And the only way you're going to get the self-defense story is if you testify, right? But a lot of other instances, you let the defense attorney do their job. And in a case like this, is he saying self-defense?
No. There's no self-defense here.
This is probably a case that sets up for, I wasn't even there.
Yeah, right? He wasn't there. He hired, or he allegedly used his ex-girlfriend as a go-between to hire a couple of hitmen to go and shoot the law professor.
There's a lot of different ways of again, it comes down to the evidence that you have. How do you go about putting on the case? What is the logical thing? Does it make sense for a defendant to testify? And if the defendant doesn't testify, all of this other stuff's not coming in, right? Mm-hmm. Those are the basic rules as it relates to evidence. That stuff's not coming in.
Mm-hmm. Yes, thank you for that bit of knowledge in a nutshell. This is a very educational interview. Do you have time for a couple more questions?
Yeah, I'm fine. Yeah.
Okay, sorry about this.
And if at some point you want to invite me back to talk about the other case, I can look into it and get back to you.
Okay, sure. I think a lot of the big time followers of this channel and the Markel case would love to hear your views on it once you've read, or assuming you have time to read more about that.